Could the SEC be moving away from regulation by enforcement? SEC Chairman Paul Atkins says the future may be built on cooperation, modernization, and clearer rules, and that could have significant implications for broker-dealers and investment advisors. At the 2026 FINRA Annual Conference, Atkins delivered one of the clearest signals yet about where financial regulation may be headed. While no new rules were announced, the speech provides valuable insight into how the SEC may approach regulation in the coming years and what firms should be watching. One of the chairman's key messages was that regulators and industry participants should not view each other as adversaries. Instead, he emphasized that both sides share the same goal: maintaining fair, orderly, and efficient markets while protecting investors. That shift in tone could create greater opportunities for firms to engage with regulators on compliance challenges, emerging technologies, and evolving business practices. Another major theme was modernization. Many of today's regulatory frameworks were developed for markets that look very different from the technology-driven environment firms operate in today. As a result, the SEC and FINRA appear interested in reviewing whether certain legacy requirements still make sense. Areas that could see continued attention include remote supervision, electronic communications, books and records requirements, digital communications oversight, regulatory reporting obligations, and broader market structure regulations. For firms, that could mean future compliance requirements become more aligned with modern business operations. Perhaps the most significant takeaway involved enforcement. Chairman Atkins reiterated his preference for establishing regulatory expectations through transparent rulemaking rather than relying on enforcement actions to create policy. If that philosophy continues, firms may see greater regulatory certainty and clearer compliance expectations. Enforcement efforts would likely remain focused on traditional priorities such as fraud, market manipulation, and conduct that causes investor harm. The chairman also emphasized the importance of economic analysis when developing new regulations. Future SEC initiatives may place greater weight on evaluating costs, benefits, and real-world impacts before imposing new compliance obligations. That approach could be particularly meaningful for smaller firms that often face disproportionate compliance burdens. So what should firms do now? Monitor SEC and FINRA modernization initiatives closely. Look for opportunities to participate in rulemaking through comment letters and industry associations. Evaluate whether compliance programs adequately address digital communications, remote supervision, and emerging technologies. And continue building constructive relationships with regulators during examinations and regulatory inquiries. A significant takeaway to the membership was enforcement. The SEC appears to be signaling a regulatory approach built on cooperation, modernization, transparency, and stakeholder engagement. While specific reforms remain to be seen, firms that stay informed and actively participate in the process will be best positioned to navigate the evolving regulatory landscape. At Legay Law, we make regulations make sense. For more regulatory updates, subscribe at legaylaw.com.